We had a cabinet meeting today, and two important decisions were taken in the cabinet. One was regarding the rules that have been framed under Section 21 of the MMDR Act, and under Section 21 of the MMDR Act, the rules pertaining to transportation, storage and illegal mining, the rules have to be framed by the state government, and this was also the observations of the NJT court, and based on that the state government has made the rules today and passed in the cabinet. The rules are called the Meghalaya Mineral Prevention of Illegal Mining, Transportation, Storage Rules 2022. These rules will apply to both major and minor minerals, and this, as I mentioned, will mostly deal with proper monitoring of the illegal transportation, storage of minerals, and to regulate issuance of mineral transport challans, and in exercise of the powers conferred under Section 23C of the Mines and Minerals Development and Regulation Act 1957. So this was the first rule that was passed today of the under Section 23C of the MMDR Act. The state governments are mandated to have rules made to check the transportation, issuance of transport challan, regulate the storage of the minerals, and also to monitor the illegal transportation. Now, in the past, though this mandate was there, the rules were never there in the government of Meghalaya for the past 30 years, 40 years now, since this MMDR Act 1957 has come out. So therefore, this was a long pending rule which should have been there. And this was brought to the notice by the NGT. And based on that, the NGT had then made provisions on their own to come out with certain provisions to monitor the movement of the trucks and the storage of the minerals and the transportation challans. But now that these rules are there, and NGT had made an observation that government of Meghalaya should come out with these rules at the earliest. So as I said, to be very, very brief, three sections are there. One is the issuance of the transport challan. Regulate the issuance of transport challan. Number two, storage of the minerals once it's taken out, storage of how it will be stored, where it will be stored. And third is to monitor any illegal transportation. So these are the three mandates that are there given in these rules. The decision that was made in the cabinet today was regarding the regularization of employees who had been working in sanctioned posts but were appointed on an ad hoc basis. As you're aware that earlier the Supreme Court had come out with this ruling, and based on that ruling, a large number of ad hoc employees and a one-time provision was given where employees without the district selection, without MPSC, or without any proper procedure or advertisement or following the different reservation policy, the departments had appointed individuals on an ad hoc basis against sanctioned posts. A large number of those people were earlier regularized as a one-time affair, but a few people were missed out. And based on the court ruling and based also on a case that has been filed by those employees who were missed out, another list of 3,635 such employees have today the decision has been made that the process to regularize them will be done, and basically based on that the procedure will start, and they will be regularized from the date of the notification of the regularization, and after the procedure and process is followed, and also they will be governed by all the rules and regulations that are there that are applicable to other government employees. So basically these employees are employees who have been working from 1997, 98, some even from 1995, but the cutoff date for us is 2007. So we are going to regularize those employees from those with the cutoff date of 2007, and those who have been now technically they've been working 15 years, if you see from 2007 to 2022. And as I said, they have been working against sanctioned post. What is very, very important to note that this is not for all casual employees. This is not for all ad hoc employees, or this is not even for temporary appointments. This is for individuals who are working against sanctioned post, who are already enjoying the pay scale that a normal employee, a regular employee gets, but they are still on ad hoc basis because the process of selection and the selection process was not followed when they were appointed. They were appointed directly as ad hoc basis, but it was against the sanctioned post, and they are receiving scale. And once they regularize, it's not that they're going to get the regular salary, they're already getting the regular salary as it is. So it's a question of just regularizing those posts. So this is very different from many other locations where temporary appointments have been made without sanctioned posts.